Boniske and Brunolli for presenting today. My company regularly works with Higgs, Fletcher, and Ed is handling a couple of matters for us right now. So I know we're going to get a lot of great knowledge today. So thank you for being here. And with that, I'll hand it over to you.
Well, thank you very much, Erica, for that warm introduction. And to everyone who I haven't met, hello, my name is Edwin Boniske. I'm here with one of our best and brightest associates, Stephen Brunolli, to talk to you today about some issues related to employment law. Just in case you don't know who we are, Higgs, Fletcher, and Mack is a full-service firm in San Diego. It's one of San Diego's oldest and largest firms. We have a single office right here in San Diego, and we represent employers up and down the state on the employment side of things. Stevie and I specialize in employment, particularly on the company side, and have been representing companies both on the advice and counsel and in defense of litigation claims for myself in excess of a decade, and Stevie for several years as well. So with that, I'm going to have Stevie tell us a little bit about why we're here, and we'll get into some meat. Oh, wrong one. Sorry, you'll have to bear with me. Trying to operate Zoom and PowerPoint at the same time is not one of my fortes.
All right. Hi, everybody. Thank you, Ed, for the introduction, and Erica as well. When you do one of these kinds of presentations, the first question is, why are we here? Why are we doing this? The we here refers to the collective group, but also Ed and myself. As Ed previewed to you all, we work here at Higgs, Fletcher, and Mack. We are a heavy litigation firm. We handle the advising clients, and we see a lot of lawsuits. And in that respect, we are sort of on the vanguard, so to speak, of employment litigation. We see what trends are happening, we see the kinds of claims plaintiffs are bringing, and we see the concerns that employers have when they're asking us for advice on these types of things. So when we were discussing this presentation, we thought, well, wouldn't it be nice to kind of amalgamate that knowledge into one presentation addressing really the stuff that we see, the institutional knowledge of the firm, and to kind of give a summary to employers as in-house counsel, just addressing those blanket concerns that we typically see. So that's what we're doing here. We're going to go over the common pitfalls that employers commit that can start running up exposure to liability pretty quickly. So we're going to have a section on overtime regular rate calculation, meal rest break premiums, and just breaks in general, wage statements, social media regulation, arbitration agreements, a discussion of expense reimbursements in there too, and then finally a employment law update with respect to several statutes that are going into effect either shortly or next year, and just some topics that might be interesting coming up.
So as dry as all that sounds, I think what you'll find is that our goal is to give you kind of a preview of the common things that we see, common pitfalls that we see employers going through, with the hope that some of this might catch your attention and you might say, oh, we need to look into that or make sure what we're doing is correct. So with that said, I'm going to talk about overtime for a minute. And you're probably thinking to yourself, why are we wasting time on overtime? This has been the law forever. Everyone knows about overtime. Everyone's been paying overtime for as long as we can remember. And that's true, but it still remains to this day the most common wage and hour claim, either in its traditional context, which is failure to pay overtime or failure to pay overtime at the correct rate, or as relevant to meal and rest breaks, which Steve will touch on in a minute. So I just wanted to take a quick minute and give you guys an overview of what we're looking at when I talk about overtime. The claim that we see right now isn't that I worked 2 hours of overtime and he paid me flat rate for all of it. It's typically that the employer thinks that what they're doing is correct and is paying an overtime rate at time and a half, but just not paying it at the right rate. So with that said, the basics here, I'm not going to waste your time reading every one of this, but in federal court, in federal states and FLSA jurisdictions, you're looking at an overtime on a weekly basis, 40 hours in a week. California does daily in addition, which means any time in excess of 8 is overtime. That's the basics. Now, the basics, though, everyone knows that when you calculate overtime, it's 1.5 times their rate, but it's actually in the statute written out as the regular rate. And the question and what drives this whole discussion is, what is a regular rate? Is it the base rate? If an employer is making $15 an hour, is their regular rate $15 an hour? Well, it certainly could be, but it could also not be. And that's what we're talking about here. It's defined by statute as the total remuneration divided by the total hours of work. So that basically means you have to take all of the income, which includes not just base compensation, but includes any other form of income, and factor it into the employee's rate of pay to figure out what you need to pay 1.5 times to equal the correct overtime rate. And let me talk about and show you what that means a little bit. So let's say you have a regular, I just put some general numbers here, right? An employee who's working for you who makes $15 an hour, hourly employee, eligible for overtime, no other forms of compensation, right? No bonus, no incentive, no commission payments. And this employee happens to work 4 hours of overtime 1 week. Okay, it doesn't matter if it's daily or weekly for the purpose of our sample, but just to show you how this works. If you're looking at a typical situation where you have no other compensation, the base rate is the regular rate, right? So you have your overtime rate of $15 an hour times 1.5 is $22.50. So you're looking at an overtime rate of $22.50. Very easy, multiply it times 4. You owe this employee $90 of overtime in addition to their base wages. Okay, that's all relatively simple, and that's the stuff that I think people can rarely ever screw up. Where it gets more difficult is when you have a bonus or other type of incentive compensation. And what do I mean when I say a bonus or other type of incentive compensation? I mean anything, literally anything other than hourly wages that is not a pure discretionary bonus. And when I say a pure discretionary bonus, I'm talking about it's Christmas time and your employer thinks you did a great job and they cut you a check for a couple $100. That's purely discretionary. It's something the employer did out of the good of its heart with no obligation either by law or by contract to do so. Non-discretionary bonuses could be anything depending on your particular mode of business and your business model. For example, you might have manufacturers in a manufacturing industry who are working towards a production bonus, right? If they produce this many units, they will get an increase in bonus. You might have someone in an office or sales environment who's eligible to earn commissions. You might have just a regular bonus program where if you complete, this number of policies, or if you remain employed with us, even in the form of a retention bonus for 3 months or 6 months, that is additional wages that are considered non-discretionary bonuses that you're going to have to look at. So when I'm talking about a flat amount bonus, the law here actually distinguishes in California between 2 different forms of bonus, one being a flat amount, which is the amount that you earn, the other one being what's called a production or shifting bonus. So for the purpose of a flat bonus, just take a hypothetical where the same employee is earning $15 an hour, works the same work week with 4 extra hours of overtime, but in that same period, they earned a non-discretionary bonus of $100. Tried to keep it simple and just say this is all within 1 week. It obviously gets a little more complicated if the bonus is earned over multiple pay periods. But for the purpose of this calculation, assume that they work for a week, there's no injuries, they get a bonus of $100, call it a safety bonus. Now you're looking at your overtime rate that we talked about before. This is the exact same calculation, and the regular amount of overtime that we owe is still $90. But you need to factor in, and in addition to that $90, pay them additional overtime premium, what I like to call overtime premium, based on that increase in the regular rate. Okay, and when you're dealing, the calculation on how you do that is different depending on what type of bonus it is. If you're dealing with a flat amount bonus, like we're dealing with here, where it's $100, then you divide it by the total number of regular hours in the work week, which in this time are 40 hours. Basically, you exclude any overtime. So because this employee worked 40 hours, that's the number you're going to use. The magic formula, and you can screenshot this or write this down, or I think you can get a copy of this PDF through the ACC later. But if you have a flat rate bonus, this is the magic formula. So you take the total bonus amount, divide it by the non-overtime hours actually worked, and we're assuming you worked 40 hours in addition to the 4 overtime. You multiply it by 0.5, and everyone asks me, why do you multiply it by 0.5? Well, because the overtime rate is 1.5, the regular rate. You have already paid them the 1 for the regular rate because you've paid them for overtime and the bonus. All that's missing is the 0.5. So it's you throw 0.5 and you multiply it by the actual overtime hours that were worked. And when you do that calculation, you'll see that you actually owe that guy $95 in overtime, not 90, simply by virtue of the fact that you also paid him $100. So that's what you call a flat amount bonus. Now I distinguish that, like I said, from what's called a production bonus. And just so you see what I'm talking about, I copied and pasted here from the DLSE Policies and Interpretations Manual. The DLSE is a state agency in California that's promulgated to both issue and they're promulgated to issue guidance, and what they do also is conduct investigations through the DAR and Labor Commissioner into wrongful employment practices. As part of that, they prepare a policy and interpretations enforcement manual, which is very useful because it's not a statute, so to speak, but it's guidance that is produced by the state into how these things should be interpreted. So with all of that lead up, section 49.2.4 basically says a production bonus is when a bonus is based on a percentage of production other than a flat amount. Okay, so what does that mean? That means we're talking about commissions. That means we're talking about widget or piece rate type bonuses, where if you produce this much, you get X much. Anything where it's not a set flat amount, it's a production bonus. Now, why does that matter? I'll show you here. It's a different formula. Then we have the exact same thing, exact same setup as we talked before, except we threw in the non-discretionary bonuses of $100 for every 10 widgets sold. So here he sold 13 widgets, meaning he's earned a $100 bonus for his production. So you do the same calculation we talked about before to get the base overtime. Not going to waste your time here. But this is the new formula, right? Whenever you have a production bonus, according to the DLSE Policy Interpretations Manual, the production bonus is earned during all hours of work, not just overtime. Therefore, the denominator at the top end here is the total hours. So instead of 100 divided by 40, you'll see we have 100 divided by 44. Meaning that for this week, with these 4 hours of overtime, you owe $4.54, which is a total of $94.54, right? So if you didn't pay him the overtime premium at all, you've underpaid him by $4.54. And if you paid him using the wrong formula, you've overpaid him to the tune of 46 cents. Why does this matter, right? I have this conversation with my clients all the time that, it seems like a whole lot of nothing. We're talking about 40 cents. But that's, I guess, the important thing that I want to drive home today is just that this has lasting and dramatic impact. And what starts as a very, very small piece of exposure can lead to something very significant. So consider, for example, you're a company who offers a production bonus, right? It's based on producing a certain number of things or units or however you might define that bonus. But you've been calculating overtime premium, thinking you're doing it correctly, using the formula for a flat rate bonus. Basically, you're dividing by 40 instead of 44 on our hypothetical. In that case, you've underpaid this employee by 46 cents in the pay period. But this also, the fact that you've underpaid them wages triggers a whole bunch of other things under the labor code, which those of you who have had the unfortunate benefit of going through wage and hour litigation are probably familiar with. But for those of you who have not been that lucky, I will just summarize for you what they are, right? We have Labor Code 226 penalties, which basically Labor Code 226 says this is everything that needs to be on your wage statement. And among those needs to be the actual amount of wages that you earned. If that is not accurate, then you have a violation of Labor Code 226 because you've underreported the amount of overtime that they have earned. That triggers a violation of $100 for the first pay period and $200 for every pay period where it's misrepresented. Labor Code 203 is what's commonly referred to in our industry as waiting time penalties. And those kick into effect anytime you have an employee who's terminated. So if you have a former employee, you all know that you have an obligation to cut them a check for their final wages at the time of termination or within 72 hours if they resign. But let's say you've underpaid him 46 cents. That means you have not paid him all of his final wages. And that penalty is pretty draconian. It actually is all of the employee's daily wages for a period of 30 days. So it's not just a penalty of a couple $1,000. It's as if they had worked for you for 30 days. You have to pay them all of that wages in the form of a penalty. And to add insult to injury, I'm sure when the legislature was putting the number 30 days together, they had about a month's worth of employment in mind. But our courts in California have interpreted that provision to actually mean 30 working days, which works out to roughly 6 weeks of working time. So that can be pretty substantial. In addition to that, we have PAGA penalties, which is just someone who can tack on a $100 per pay period penalty for saying that you didn't do these things correctly. In addition to attorney's fees, both yours and the other side, because there's one-way fee shifting statutes and prejudgment interest at the low rate of 10%. So just looking at those numbers, right, it's pretty shocking that 1 week of 46 cents underpayment, assuming this implied, Randy's numbers, assuming the guy worked for you for 3 years. If that's the case, you owe him $71.76 in overtime, which would derive to several $1,000s of Labor Code 226 penalties, but there is a cap at $4,000, meaning they can't exceed that, so I put the cap in there. Labor Code 203 penalties, we're looking at $3,600, and that's just based on $15 an hour times 8 hours a day times 30 days. Adding in some PAGA penalties, you're looking at north of $7,000, not factoring in prejudgment interest, fees, etc. So that's with one former employee who'd been with you for 3 years. Now consider if this is a system-wide problem, right? Where you have been calculating this to the tune of a couple pennies off for a period of time for a number of employees, right? This number then multiplies exponentially. With one employee turns into 100 employees. Obviously the numbers get multiplied by 100. So it's not something that's insignificant. And for that reason, it's one of the most common claims we see. As an employment lawyer, I think I can speak for all of us when I say that most plaintiffs who we see filing lawsuits in the wage and hour realm likely don't go to a lawyer saying, I think my company underpaid me in 46 cents in a week per on a payroll period. They go there thinking, you know, I did something wrong. I was wrongfully terminated. They discriminated against me. And the lawyer says, well, let me take a look at your pay stubs and your wage statements. And then you might get a letter from a lawyer asking for wage statements and pay stubs and personnel file materials. And all of that is so the lawyer can then look at this and run some numbers. This is a very easy thing to catch. You either did it right and you did it wrong. And it's a matter of how much if a plaintiff's lawyer gets a hold of it, because there's really no defenses. So with all that said, this is something that's it's dangerous territory. But like I said, it's simple as making sure you're doing it right. So audit your payroll practices, right? I tell everyone, put yourself in the shoes of a former employee, going to see a plaintiff's employment lawyer, and look at a stack of wage statements and time cards, right? Are there other forms of compensation on there other than hourly or salary? And if there are, you know, look at, am I calculating it correct? If you do have other forms, you need to look at and double check that you're actually doing the calculation right. Because unfortunately, I've had the unfortunate benefit of representing a few employers who thought they were doing everything correct, but it turns out they had a wrong number in the total number of hours in the denominator. Or they might screw up and include things like sick accruals and sick time that was paid when they're calculating the total hours worked, which obviously then results in an underpayment because it increases the denominator to the tune of pennies, but it can be substantial. So this is a big danger zone. And if I could leave you with one thing today, it would just be to double check, right? If you think you're doing it right, great. If not, double check, make sure that you are, because this is dangerous territory. With that said, I'm going to get off that. I'll let Stevie talk about how this is relevant to meal and rest breaks.
All right. Well, whereas Ed was talking about the most common claim that plaintiffs bring, meal and rest breaks is probably the most annoying claim that plaintiffs can bring. And it's also a very common one as well, and that's largely because of how difficult it is for employers to disprove the plaintiff's claim. I won't bore you with the strict law on breaks. I think we all more or less know how it comes down. You get a 10-minute break for every 4 hours or major fraction thereof, 30 minutes for every 5 hours, and another 30-minute break if the employee works over 12 hours. And then if an employee doesn't get the break, they get a meal period premium at their regular rate of compensation. That's the strict black letter law of it. This has been a very intensive litigation area in recent years, largely because of the fact that it's difficult to prove, it's difficult to disprove, and at the end of the day, it's often a employee said, employer said kind of thing. As much like the wage and hour claims, this is one of those things that can just be tacked on. An employee thinks they've been wronged, they're wrongfully terminated, they were discriminated against. They go to a plaintiff's counsel. It's very easy for plaintiff's counsel to say, oh, well, did you ever miss a break? Or did you ever get interrupted during a break? Were you ever not afforded one? Oh, okay, great. We'll throw in a break claim too. And then that opens up discovery. Now they're looking at all your logs, your policies, etc. So again, this is something, thank you. This is something we see a lot. It's not something that's easy to prevent the claim from coming in or from having the lawsuit be filed because of those reasons. But we do have 4 best practices that we always give our employer clients that will not necessarily win you the suit or prevent the suit from coming in, but will certainly help not lose it. The first one is documentation. Of course, we know that employees have to clock out for their meal breaks. They clock back in. That's not what we're talking about here. When we say to document things, we mean during some interval, whether that's weekly, daily, per paycheck, what have you, it's a good practice to have the employee review their hours and sign off on them to say, these hours are correct. They haven't been altered. They haven't been changed at all. These are exactly the hours. These are the exact times I clocked in and out, signed off on it. You can also have the employee regularly sign off that they've received all their breaks this week. If you want a complete overkill, you can have them sign in and out for their 10-minute breaks, but be aware that that's opening a can of worms, so to speak, because now you have this massive paper trail, and that itself might open you up to liability. So just having some sort of way of documenting the employee saying themselves that these are correct, because then when you get to the court, it's the employee's word against the employee's word, just his contemporaneous word versus now his perhaps incorrect memory. So that's the first best practice we usually offer. The next is scheduling. And by scheduling, I mean audit your schedules. Look at the schedules and make sure that there's overlaps of employees or that there's room for everyone to take their breaks. Because it's the easiest thing in the world for a plaintiff's attorney to get your schedules and say, look, Your Honor, my client was the only one scheduled to be on the premises that day. Of course they didn't get breaks. She couldn't have, even if though they have a policy that says she has to close the store for 10 minutes every 2 hours, I mean, she couldn't have actually done that. So to the extent that there's any sort of gaps in the scheduling, you just want to make sure that your schedules look and that they actually are such that everyone can take breaks. I'm going to come back to auto payment because I want to skip to policies because it's related to this. And that is that it's very important to have ironclad policies that mirror the law itself. Again, this isn't something that you're going to win the case on, but most certainly it is something that if you're not doing it right, you can lose the case on or turn your case into a much bigger case. For example, in reviewing employers' break policies, many of them we see sometimes at least, that they leave off the or portion thereof language. And leaving that off, it's again an easy thing for a plaintiff's counsel to take that to a judge and say, see, Your Honor, they actually have a policy of not giving compliant rest periods. So you should turn this into a class action. You should certify a class on this rest break claim, and now all of a sudden you have $100 million loss. So especially in this area of meal and rest breaks, it's important to update your policies regularly because the law is constantly changing. And in the next couple of slides, we're going to actually talk about a few cases that came out in the last year and a half or so that have substantially changed the law on this. And the final best practice is auto payment as default. This is made in respect to the break premiums for when an employee misses their breaks. I can't say with certainty, but I can say with a pretty good confidence that every payroll system has this setting. You can turn on a setting to where if the employee takes a non-compliant break, whether it's a short meal period or a late meal period, a premium will be automatically applied to that pay period. It doesn't mean that it can't be taken away, that you can't review the wage or the payroll information and take it away and realize, oh, this was an errant clock, or we sent her home, or whatever. You can fix it before the money goes out and before the pay period ends. But if you have this set as an auto default, it goes a long way towards setting up your defense in front of a judge. You can say, well, Your Honor, we have this automatic system set up. Employees automatically get paid a premium. And in fact, in the last 3 years, we've only reviewed and taken away 3 premiums. And here's why, X, Y, Z. And that's very helpful when you're trying to make your case that not only do you give meal breaks, but you give rest breaks too. So here's some of these cases. The UPS case, that's kind of an older case, but still a question that gets asked, which is, well, if an employee misses a rest break and a meal break in the same day, do they get 2 penalties? And the answer to that is yes.
And so Stevie's going to talk about now this next case, which I think is a big turning point in where we've come from and where we're going now, right? So we've talked about, from my perspective, overtime and the regular rate and how that all factors into things. There's actually been a decision now that helps carry that into the meal break area as well. So it's no longer just a concern for overtime. Take it away.
Right. So this case, the Farrah v. Lowe's Hollywood Hotel case, in years past, if you recall, the statute for meal and rest period premiums says that the employee should be compensated at 1 hour of the regular rate of compensation. And for many years, that language was taken to mean their hourly rate, their base hourly rate. They get 1 extra hour of that. And finally, maybe finally is not the right word, unfortunately, finally, in 2021, mid last year, this Lowe's Hollywood Hotel case came out. And that case determined that the regular rate calculation is not the base hourly rate, but rather you must pay the employee at 1 hour at the regular rate overtime calculation. So everything Ed was just talking about, that kind of sticky, muddy waters as far as calculating these bonuses.
So in essence, if your employee misses a meal break or clocks out late for their meal break, instead of giving them the $15 that we talked about before, owe them 15 plus whatever the pennies are to make it up to the regular rate. And if you paid them only the 15, you've now underpaid them. Why does that matter, Stevie?
And that matters because a case that came out earlier this year, Naranjo v. Spectrum Security Services, Inc., determined that these meal and rest period premiums constitute wages for the purposes of waiting time penalties and for wage statement claims. So all those parade of horribles that Ed was talking about earlier that get triggered when you mess up one small thing, well, they get triggered now for meal and rest period premiums as well. And we've seen this come up with some frequency recently because a lot of employers we have seen have been instituting bonus programs during COVID to either keep workers or incentivize workers. And just be aware that if you do that, you have to be including those bonuses in the overtime calculation and now also in the rest premium calculation. The takeaways here is don't rely on your payroll company. We've said that before. You're paying them to get it right, but that doesn't necessarily mean they're getting it right. Or
take a look at the fine language of your agreement with your payroll provider too, and I guarantee that they're not taking responsibility if it's not coming up right. In fact, that's all on you. Mm-hmm. So even if you rely on them, make sure you check it.
And frankly, also, if you're telling the payroll company this is a flat rate bonus when it's really a production bonus, that's on you. So the takeaway here is audit your pay records to ensure compliance. The Sfera, the Lowe's Hollywood case is retroactive. So to the extent that you have been underpaying employees, it's a wise decision to do some true ups so you can minimize liability moving forward. And then finally, reconsider any non-discretionary bonus programs. I know that the labor market is cooling off a little bit. So maybe some of those programs that were there to incentivize workers may not be necessary anymore.
So I'm going to now turn to, I get all the exciting topics, right? Wage statements. Really, I'm not going to bore you guys with the details other than to tell you this is one of the most common things that I still see coming across my plate to this day. I can't tell you how many times we get a complaint for X, Y, and Z, but it also includes a derivative claim for a wage statement, or more troubling, a direct claim. And what do I mean when I say that? So Labor Code 226 is what governs wage statements. 226A has 9 enumerated items that have to appear accurately on every wage statement. And when I say wage statement, I'm talking about the piece of paper that goes to the employee with their check, right? That has to list all these things. I'm not going to read every one of them, but just understand that there's no discretion here. All 9 of these things need to appear on the face of the pay stub. When I say a direct violation, those are ones that are rare, but still shockingly common considering how easy this is to prevent, right? Look at your wage statement. Make sure it lists things including the employer's address. You'd be surprised at how many people have the employer's name, but not the address. The employee name and the last 4 of social or their employee ID number. Sometimes it'll have one or the other. Oftentimes it'll have a pay date, but it won't also list the inclusive dates of the pay period. Again, these are all things that I think if you just take a look at your wage statement, you can make sure they're all there. You're not going to be able to do anything by looking at a wage statement to avoid a derivative claim. A derivative claim is what I said earlier, which is it's based on the idea that it's not accurate according to the language of the statute. So if you have underpaid wages by virtue of overtime or meal break or rest break premiums, as Stevie just explained, you will have not accurately reported their gross wages as listed here on item number 1. So if you do that, it can trigger a violation of 226 derivatively. What my point of this today is just pull out a copy of 226 or this slide, pull out a copy of your wage statement and just make sure that stuff's there. There's a few, this is just simple stuff to avoid a direct violation and a direct claim. And it's easy things to clean up because if there is a no claim, you can always issue amended pay stubs before anyone leaves and these penalties are triggered. What do I mean when I say penalties, right? So I mentioned it earlier, but just so you see what it means, if you screw up, you're looking at $50 for the first paycheck and $100 for each one afterwards, capped at $400. And that's outside of the PAGA context. If someone brings this at the same time they bring a claim under what's called the Private Attorney General's Act, that $100 per pay period becomes $250 per pay period. So again, just look at it, make sure that and if you have any questions, ask. Next thing I wanted to touch on quickly is social media. Right? In today's environment, it's a bigger and bigger headache for employers dealing with their employees on social media. And when I say that, I'm not necessarily talking about the person who's running the company's Twitter account or the company's Facebook account, although those can be problematic. I'm talking about just your employee on their personal time, posting something on their phone, probably not thinking twice about it, but it impacts the business. And what can you do to regulate that? And these types of claims come up, and we hear them all the time, more and more now. Since we've moved past kind of the COVID thing and people are getting back to work, we're seeing more and more of these issues where employers are having to defend this. So just, what do I mean? This is a silly example of someone who posted online of themselves actually at work licking a stack of taco shells. I think we can all guess what happened to him. He's been redacted for his own privacy. Another one here, just an example, right? This is a nurse who worked at a hospital who posted that she's basically bored and wants someone to code so she'll have something exciting to do, and tagged the name of her hospital right below it. Again, I've redacted it for privacy, but these are things that are obviously a PR nightmare from the company standpoint. But what can you do about it? Right? That's where I'm trying to focus here. You can be responsible for liability that arises out of their social media use, right? So if an employee is posting defamatory, discriminatory, harassing stuff, if they're revealing trade secrets, if they're violating contracts, or revealing HIPAA information, the employer, you can be responsible for their conduct. Sometimes, but not always. The key is looking at when it involves protected activity, okay? An employer can't regulate an employee who's engaged in protected activity. So while you may want to discipline and punish the employee who's taking a picture of himself licking all the taco shells in the back of your restaurant, you can't do that if it is social, if it's considered protected activity. And what does that mean? So protected activity is something that is defined and really operates under the NLRA. And oftentimes when I raise the NLRA, my clients say, whoa, Ed, we don't have any unions. We don't have a collective bargaining agreement. We're a non-labor shop. So the NLRA doesn't apply to us, because everyone knows that, or most people know, I should say, that the NLRA is what governs things like organized labor and unions. But what a lot of people don't know is that almost every private sector employee is actually covered by the NLRA in some way, shape, or form. Now, what the NLRA does is it protects employees' ability to basically confer with themselves about the nature of their employment or the terms of their condition of employment. So Section 7 of the NLRA specifically gives employees the right to engage in what's called concerted activities for the purpose of collective bargaining or other mutual aid or protection, right? So that last part means it doesn't have to be a union, doesn't have to have anything to do with a union. It just has to do with the mutual aid and protection of your employees. It doesn't matter whether it's on the internet, social media, or in person. The nature of the protected activity under Section 7 is all the same. So where we see the interplay between these is when an employee will post something online and you have to ask yourself, can I regulate this? Can I take conduct? And if I do take action to, let's say, discipline or terminate this employee for engaging in that, am I going to be in violation of the NLRA? When looking at concerted activity, this is just a test for you to look at. It's basically 2 or more employees taking action for mutual aid or protection. And the way I like to dumb it down is just if you have 2 employees talking about the terms of their employment, that's when you're in the danger area. I guess then using the language of the statute, it's when it's not solely for the benefit of the employee. So if you have guys who are online or 2 employees who are discussing their compensation, asking for a raise, what the bonus plan is going to look like this year, that's protected activity. And you can't regulate the employees for discussing that even publicly. Unprotected activity, right? Now, there's things that you can take action for, including personal gripes or things that are specific to the individual himself. If an individual is raising a concern that only affects him, that's not going to be protected. Section 7 also has an out. Basically, if it's a reckless or malicious disclosure by the employee's part, it won't be protected even if it is in terms and conditions. So that's a whole lot of black letter law, but let me show you what this looks like in real life. So I took 3 real cases from the NLRB, and the NLRB, the National Labor Relations Board, is the entity that enforces the NLRA, the National Labor Relations Act. I've anonymized it a little bit just so we can make it into a hypothetical. But in this situation, as you'll read on the screen, we got an employee who's in a dispute with his coworker about whether he's doing a good job. And one of them, off duty, on his computer at home, posts something on Facebook saying, hey, my coworker thinks we don't help our clients enough and he names the company. I've about had it. How do you feel, everyone else? And 4 other people, also off duty, responded, defending their work performance, defending the customer service. Employer finds out about this and says, whoa, 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 why are we debating whether we provide good service in the public forum? Fired all of them. Is that protected or not protected? 3, 2, 1, that's protected, right? And then, you know, as it's shocking as it sounds, the NLRB actually found that there was no question that they were engaged for the purpose of mutual aid or protection with respect to their employee who was basically saying his job performance was being criticized at work. So them talking about their collective job performance and defending their job performance was protected. The employer was in violation of the NLRB and suffered a decision. I put the website there at the bottom in case any of you are interested in looking. Another 2 quick hypos, right? An employee, let's say it's a car dealer. This guy works at a BMW dealership, saw an accident next door at the Land Rover dealership. They're actually owned by the same person. He posts a pic of the accident where actually the Land Rover had gone into a pond and fountain in front of the dealership and said, see, this is what happened when a salesperson in the front of the passenger seat allows a 13-year-old boy to get behind the wheel of a 6,000-pound truck designed to drive over anything. Kid drives over his father's foot and into the pond in 4 seconds and destroys the truck. Oops. Well, you know, the employer saw this and said, well, we don't like that. Obviously, that's a problem from our perspective. But online, his coworkers respond and comment, right? How did I miss all this stuff? Wow, finally some action at Land Rover. Now the owner who owns both of these gets calls from other Land Rover dealers who've seen these pictures and stuff online and fires everyone. Says, hey, the people who commented and the guy who posted it, you're all fired. Is that protected activity? 3, 2, 1. No. You're asking yourself, how could that not be in the first one was? Well, the only difference is that this had to do with this wasn't have to do with the terms and conditions of his employment. Okay, he was just merely commenting on something that had happened at the other dealership. It was embarrassing to the owner. It was embarrassing to the dealership, but it had no connection to the terms and conditions of employment at all. So that you can fire him for. Last one. This is employees at a catering company, right? There's some nasty facts here, but the very short version is that the employees were complaining about their management, said their managers take out their frustration. They don't treat us with respect. They were going through and getting ready to do an election for a potential unionization of the workforce. 2 days before one of the elections, there was an issue and an interchange between these 2 guys where one of them told him to stay strong. And then during a rest break, while he's on the job, employee who's actually being criticized, goes on his phone, and you'll see the quote there, dropped about 5 F-bombs, F his mother and his entire family, what a loser, terrible, terrible things, all right? And this is posted online, with reference to the company. He gets fired, obviously, because the company said, well, we can't have that. We don't want that. That's protected, right? And this is a little bit more nuanced because the court there looked at the totality of the circumstances. It basically said this was an impulsive reaction. We don't necessarily approve of his profanity, but we don't use it to be qualitatively different than any other profanity that he might have got on the job. And he's talking about staying strong in his dispute with the managers, which impacted everyone for the unionization. So this is one that the takeaway is that you just, from your perspective, know that the NLRA applies to you. Right? You may not know that now or before this, but you should certainly know it now. I'm hopeful that you'll never have a situation in you where you have to deal with a rogue employee who's posting things about your business or which can be embarrassing to your business. But to the extent they do, understand that some of it can be protected and some of it can't be. So pay close attention to that and make sure that if you're ever making decisions in that space, use some caution. We got about 10 minutes left, and we're going to run through just a few things to wrap this up. If I'm not sure we're going to have time for questions, but if so, we'll open it up. Stevie, do you want to give us an overview on arbitration and where we are now?
Yes, yes. If you all recall, or if you were on the presentation a few months ago, early in the summer, some colleagues of ours gave a presentation on PAGA, the future of PAGA, in the context of a case before the Supreme Court, Viking River Cruises, Inc. v. Mariana. And that case has now been decided, and it brought the law on PAGA waivers largely in line with the law on class waivers, with some slight tweaking. The holding of that case essentially held that an arbitration agreement can force or require an employee to waive their representative components of a PAGA claim and arbitrate the individual component of their PAGA claim. And the court said that is a perfectly acceptable waiver of the representative portion. The key, though, is that the court determined that an arbitration agreement cannot waive the entire PAGA claim. Rather, it can just, it's allowed to allow a employee to bring the individual component into arbitration and waive the representative component. The key issue that we're seeing is that a lot of older arbitration agreements are still using entire waiver language. They're roping representative claims or PAGA claims into the sentence with the class action waiver and having the employee waive everything in one fell swoop. So it's very important that you review if you're interested in having a PAGA waiver, that you review your arbitration agreements, have an attorney well-versed in PAGA litigation review the arbitration agreements, just to make sure that it still allows the individual PAGA component to proceed in arbitration. If you do that, you're in the clear.
Let me just capstone that real quick. So if you have an arbitration agreement that has a class and PAGA waiver, depending on how it's written, you may need to change it. Just because you can't have a waiver of the right to bring a PAGA claim, you can only have a right to waive the representative portion of the PAGA claim. So,
and of note, at the end there is Viking River. The holding of that case might be short-lived. There is currently a case in front of the California Supreme Court that is addressing some of the perceived deficiencies of that ruling. So keep your ears to the ground on that one.
This is going to be a very brief topic, and I'm raising it only because I've gotten probably 5 calls on this subject in the last 2 weeks. Everyone knows, or I keep saying everyone knows. Let me back up. As employers, you should be familiar with your obligation to reimburse employees. Now, reimbursing your employees for expenses that they incur when they do jobs, whether that's mileage, whether that's cell phone bills, whether that's travel costs, the employer has a duty to pay. That derives from Labor Code 2802, right? In Labor Code 2802, I didn't quote the language here, but the language of the statute says that the employer must indemnify its employees for all expenses that are reasonably incurred in the discharge of their duties. And what a court said that means, there's basically 3 things. The employee incurs an expense in the direct discharge of their duties, and it was reasonable and necessary. Now, reasonable and necessary is the question I've been getting a lot, right? In this situation, do we have to reimburse? In that situation, do we have to reimburse? Now, prior to COVID, we were talking about primarily mileage, travel, basic stuff. When COVID started and a lot of people started working from home, I think a lot of employers expanded their understanding of what might be reasonable and necessary in the form of at-home expenses, whether that be cell phone, home office supplies, internet access, all those things that an employee could arguably say were necessary and reasonable for them to do their job remotely if they didn't have the ability. Now, the reason I raise it today is the questions I've been getting are, what if it's not necessary, right? So let's say, for example, you have a payroll process or payroll system that's digital, Paychex, ADP, they all offer apps, right? That your employee can go to their phone and click a button and clock in on their phone right then and there. Is that now them requiring them to use their cell phone for the purpose of recording a business document, right? Keeping a necessary business record? If so, you have an obligation to reimburse it. If not, no. You also see this commonly with outside of that with respect to home Wi-Fi expenses. If we have someone who we're requiring to work from home, or we're designating that's your home office, that's one thing. But what if we have the option for them to work here and they prefer to work at home? In that case, it's arguably not necessary. My point of all this is that it's a gray area, right? The law says you have to indemnify them for anything that's reasonable and necessary. And what's reasonable and necessary is what a jury or judge is going to agree is necessary. So the best you can do, and I think the most important thing you can do to minimize exposure, is to look at what type of expenses your employees might be incurring. And then with that knowledge, look at what you might do to put in policies to minimize the necessity of it. So using the example I used of the person who's clocking in on their phone, you might have a timekeeping policy that specifies that although this feature is available and we won't prohibit you from using it, it's not necessary. We expect you to clock in using our devices, and to the extent you're doing it solely because you desire to do so. So that you can then turn around and argue, if you ever sued for this, that it wasn't necessary. So that's just it in a nutshell, is focusing on what's necessary. And I guess my takeaway would be that if you have expenses and it's even questionable, do either err on the side of paying it and reimbursing it, or B, implementing very detailed policy language to eliminate any argument that it could be called necessary in the future. Stevie?
All right, we're running low on time, so I'll run through these fairly quickly to see if there's any questions out in the audience. But here's some statutes or laws that are going into effect either next year or are in effect right now that we thought would be interesting and maybe cause some issues on the horizon. The first, and this goes to James's question, is SB 1162. This was a law that was passed earlier this year and goes into effect next year. It modifies the reporting requirements for employers to the state, but importantly and interestingly, it requires also employers with employees over 15 people to post the pay scales on job listings. It remains to be seen how that's going to play out. Whether how big the scale can be, whether it's the lowest paid up to the highest paid, we'll see how that all comes out. The next is that there's been extensions to the COVID pay, the supplemental COVID pay. That now is going, it was supposed to end in September, I believe, and it has been extended now through December. They've also extended the workers' compensation presumption that if somebody catches COVID, we presume that they caught it on the job. That's been extended as well. The next, and this is going to be a really hot topic coming up in the coming years, is California is started what's called with the Fast Food and Accountability Act, they have essentially created I guess you could describe it as a government sanctioned union for an entire industry. And this is in the fast food industry that's going to bargain or set wages for fast food workers. The details of this are also pretty slim. It's going to be a really, truly interesting thing to see unfold. They do some of this in Europe, but it's never been done here. And then finally, before the Supreme Court right now, in addition to the other PAGA case, there is one that is going to determine whether trial courts can strike PAGA claims that are quote unquote unmanageable. So where it's a huge sweeping, and this is great for employers because trial courts some have stricken PAGA claims that are sweeping and are looking to incorporate hundreds of thousands of workers, or that's an exaggeration. So that's what we have on the horizon. We are running short on time, so I'll open it up for questions if you have.
Yeah, so just to capstone that, on the PAGA side of things, the unmanageable, as many of you may have known, so from a class action thing, if someone sues you for a class action, says you didn't give everyone a meal break, or your policy is unlawful. There's due process protections that protect an employer. One of them, and I guess the most significant, is class certification, meaning that the plaintiff's lawyer and the plaintiff would have to prove that their case is of the type that you can actually apply it to the whole group, right? It's common, the claims are common, they're typical, this is a superior way to do it. There's a number of factors you look at. There is no such equivalent in PAGA, meaning that you can file a claim, you can file it on behalf of everyone, and there's no safeguard between the filing and trial during which the court can say, wait, should we really be trying the claims of all 50 or all 100 or all 1,000 of these people the same? Is it really the same? So employers have been attacking that from a manageability standpoint, saying, Your Honor, we can't do this. It's just an unmanageable case. So it's just another level of defense to help prevent what we call large scale or class representative litigation for employers. So with that said, I think that's, hang on one second. Here we go. See, that's all, folks. That's the presentation that we've prepared. Again, just an overview of where we are and kind of some hot topic issues that we see coming across our desk on a day-to-day. We do have, looks like 30 seconds left. So I apologize. We don't have time to get into any specific questions right now. But again, thank you all very much for your time attending today. And we'll hope to see you guys again at the next one.
Thank you all.